interact with land every single day, right? I mean, the ground beneath our feet, the home we live in, the place where we work.
Absolutely. It's fundamental.
But have you ever really stopped, to think about what land actually means in the eyes of the law? Or just how deeply its rules impact our daily lives?
It's a concept that's way more intricate, really, and expansive than just, dirt and trees.
Yeah. So today, we're taking a deep dive into this fascinating world of land law. We're drawing insights from legal frameworks, looking particularly at Uganda and Tanzania. And this isn't about, dry legal textbooks. It's more about uncovering the surprising foundations and, the practical implications of property rights that really touch everyone.
Exactly. Our mission really is to demystify land law for you. We want to extract the most important nuggets of knowledge and show you why understanding these principles is so crucial, even if you're not a legal expert.
Think of it as your shortcut, maybe, to being genuinely well-informed about the very ground you stand on.
Yeah, exactly.
Okay, so let's kick things off. Defining land. When you hear that word, you probably picture what? A plot of dirt? Maybe some trees?
That's the common image, sure.
But legally, it's far, far more expansive.
That's right. When the law talks about land, it definitely extends beyond just the physical surface. We're talking about everything that's sort of permanently attached to it.
Right, buildings.
Buildings, structures, yeah. And even intangible rights associated with the property. For example, in legal terms, land can include things like messuages, that's a kind of old word, but it means a house with its outbuildings.
Okay.
And hereditaments, which just means anything physical or even an intangible right that you can inherit.
Okay, this is where it gets really interesting, I think, especially for anyone who's ever thought about home improvements. There's this principle, quid plantutur, solo seated.
Ah, yes, the Latin.
Which basically means that which is attached to the land goes with the land.
Right, exactly.
And what's fascinating here is how this applies to fixtures. So, imagine you renovate a kitchen, you install a custom-built island.
Yeah.
Is that island still, your personal property, or does it become part of the house and therefore part of the land?
Good question.
The law asks, was the item attached to permanently enhance the property? Or was it just, for the temporary enjoyment of the item itself?
So paintings you can take down easily, that's personal property.
Usually, yes. But that custom kitchen island, designed to fit, built in, it's very likely a fixture.
Wow.
And the surprising consequence is, if you install it in a house you're maybe buying, and then the deal falls through, that island might just stay with the house, not with you.
That's something to keep in mind. Okay, so if I own the land, does that mean I own the air above it?
Yeah.
To an unlimited height? Forever, way up into space.
Ah, that's a great question. And there is an old legal saying, quidus est solum ejus usque ad coelum, which means, the owner possesses up to the sky.
Right.
But courts have had to find a balance, especially in the modern world. There's a well-known case, Bernstein of Levy Skyviews.
And the court basically decided that a landowner's rights only extend to the airspace necessary for the, let's say, ordinary use and enjoyment of their land.
So not infinitely high.
No, you can't stop a plane from flying, miles above your property. That would just hinder public use of technology, air travel. It's about reasonable enjoyment, not absolute ownership into the stratosphere.
Got it. That makes sense.
So the foundation of land law in any country, really, always starts with the highest legal authority.
Right.
The Constitution.
Right.
In Uganda, that's the 1995 Constitution. In Tanzania, the 1977 Constitution. These big documents, they lay out the fundamental property rights.
Okay.
Then underneath those, you get various specific laws like land acts that govern all the details of how land is owned, managed, transferred, and so on.
Okay, but what about, deeply rooted traditions, practices that have been around for ages? How does something like customary law fit into this modern legal framework?
That's a really important point. Customary law is basically the unwritten rules and usages developed by African communities, often over generations, and they're accepted as having real legal force. It's incredibly significant.
But it's not absolute.
No, it's not absolute. There's a key limitation. It must not be repugnant to natural justice, equity, and good conscience.
Meaning?
Well, essentially, it means it can't be fundamentally unfair or go against established written law. For example, a court might reject a custom if it unfairly deprives someone, say a widow, of family property, if that custom is seen as violating basic principles of justice.
That makes sense. And speaking of fairness, how does the law step in to protect vulnerable groups? Especially if, some customary practices might not have originally accounted for them.
That's critical, and modern law does address this. In Uganda, for example, the Land Act specifically makes invalid any customary rule or practice that denies women, children, or disabled persons access to land, whether that's ownership, use, or occupation. So this really highlights a crucial dynamic in land law. It's constantly evolving. You see modern statutory law stepping in to make sure fundamental rights and fairness are upheld, even if they sometimes conflict with older traditions.
It's a balancing act.
Definitely. Now, in a country like Uganda, land is typically held under 4 main systems of tenure. You've got Malo, freehold, leasehold, and customary.
Okay.
And each system defines exactly how rights and interests in land are held. It's almost like different types of ownership packages, if you like.
Let's break those down then. What exactly is Malo land? That sounds a bit unique.
Malo land is quite unique, yeah. It stems from a specific historical agreement in Uganda, the Uganda Agreement of 1900.
Okay.
And it was initially seen as an absolute grant of land in perpetuity, meaning forever, very similar to owning land outright in common law, like a freehold. But over time, regulations came in that restricted its transfer or leasing, particularly to non-Indigenous Ugandans or certain organizations. So while it's a very strong form of ownership, it does come with certain historical caveats and restrictions.
Interesting. Okay, and what about freehold? How does that compare?
Freehold is often seen as the most extensive interest you can have in land. When you hear the term fee simple, that means perpetual forever and inheritable ownership. For all practical purposes, it's pretty much equivalent to full ownership of the land.
Right. And leasehold, that sounds more familiar.
Leaseholds are temporary grants of possession. This is much more of a contractual agreement, like renting an apartment or an office. You have the right to use the land for a specified period, and it creates that classic landlord-tenant relationship.
Okay. And customary tenure, which you mentioned earlier, how does that work in practice?
Right. So customary tenure, as we said, it's deeply rooted in community usage and traditional practices. In Tanzania, for instance, it often operates on a first right principle.
Right.
Meaning the indigenous groups who first settled an area claim the land. They can then allocate parts of it to newcomers, according to their customs.
Can this be formalized?
Yes. There's actually a process to get a formal certificate of customary ownership. It's quite structured, involving local committees, public notices, community meetings, mediation if needed, and eventually land board approvals. It's a way for the modern legal system to formally recognize and protect these long-standing community-based land rights.
Got it. Okay, let's shift gears a bit. I find this fascinating. Historically, English land law had this sort of dual system. There were the common law courts and then these equity courts. Why did that happen? And how does it still affect land ownership today?
Yes, the history is quite revealing. The common law courts back in the day were incredibly rigid, very formalistic. If your specific case didn't perfectly fit an existing legal procedure, what they called a writ,
You were out of luck.
Pretty much. You simply had no remedy, no matter how unfair the situation felt. So people started petitioning the king directly, who was seen as the ultimate source of justice. This led to the king's chief advisor, the Lord Chancellor, developing a parallel court system, the Court of Chancery. And it operated based on principles of equity, fairness, reason, conscience, trying to achieve just outcomes where the strict common law fell short.
What's fascinating here is how these two systems eventually sort of came together and what powerful ideas came out of that mix.
Exactly. The Judicature Act of 1873 ultimately fused the administration of common law and equity. So the same courts could then apply both sets of principles.
Okay.
And a cornerstone principle of equity that emerged and is still really important is equity regards as done that which ought to be done.
What does that mean in practice?
Well, think of it like this. Say you have a handshake agreement, maybe even a written note, but not a formal deed, to lease land for 7 years. And you start acting on it, paying rent, maybe making improvements. Even if the formal legal paperwork, the deed, isn't signed as required by law, equity might step in and say, look, you both intended this lease, you acted on it, so we're going to treat it as if it were a valid lease. It holds people to their promises even if the formalities aren't perfect. The classic case is Walsh v. Lonsdale.
Okay, so practically speaking, for someone buying property today, what's the real-world difference between having a legal interest versus an equitable interest?
That's a key distinction. A legal interest is generally considered absolute. It binds everyone, the whole world, regardless of whether they know about it. It's like fully documented, rock-solid ownership.
Right.
An equitable interest, though, is a bit more nuanced. It definitely binds the specific parties involved, like a trustee and beneficiary or someone who knows about a prior claim. But, and this is crucial, it generally does not bind an innocent third party, a bona fide purchaser who paid good money for the property and had no notice, no idea about that earlier equitable claim.
So being unaware protects the new buyer.
If they bought the legal estate, paid fair value, and genuinely had no notice, yes, generally. Imagine two people claiming the same piece of land based on different agreements with the seller. The general rule is first in time, first in right. But that only applies if the equities are equal. If the first person was, say, really careless or even fraudulent, and that allowed the seller to trick the second person into buying, well, then the first person might lose their priority because the equities aren't equal anymore. Their bad conduct tipped the scales.
Wow. Okay, so diligence really matters.
Immensely, especially checking the official register, which aims to provide that notice.
Right. Okay, here's where it gets really interesting, I think, in terms of fairness. What happens if someone, maybe mistakenly, builds a house or makes significant improvements on land, believing it's theirs, or maybe that they'll get an interest in it, and then the true legal owner shows up?
Ah, yes. This brings us to a concept called proprietary estoppel, and it's a really powerful tool the courts use to prevent unfairness. It's basically a limited exception to that rule we talked about earlier, that anything built on the land belongs to the landowner, quid plantator. Proprietary estoppel says, wait a minute, if a landowner stood by and watched someone build knowing they were mistaken,
Or even encourage them.
if they created or allowed an expectation that the person would get an interest, and that person then acted on that expectation to their detriment, like spending money building something, then the landowner can't just turn around later and say, thanks for the building, now get off my land, without any consequences. The court can step in to satisfy that equity, that fairness.
Can you give us a real-world example? That sounds like it could get complicated.
Absolutely. There's a famous English case, Inwards v. Baker. A father basically suggested to his son, why don't you build a bungalow here on my land?
Okay.
The son did just that, spent his own money, built his home there. Years later, the father passed away. The father's other heirs, who inherited the land legally, then tried to kick the son out. But the court said, no. They applied proprietary estoppel. Because the father had created that expectation and the son acted on it to his detriment, spending money, building, the court prevented the heirs from evicting him. They granted the son what amounted to an indefinite license to live there for as long as he wished.
So it's really about stopping someone from acting unfairly, or unconscionably, as the lawyers say.
Exactly. Preventing unconscionable conduct is the core idea.
Okay. So what does this all mean when, say, more than one person owns a piece of land together? Or maybe when someone needs to use a neighbor's land, perhaps just to get to their own property.
Right. That brings us into the realm of co-ownership and servitudes. Let's take co-ownership first. When two or more people own land at the same time, concurrently, they typically do it in one of two main ways.
Which are?
As joint tenants or as tenants in common.
Okay, what's the difference?
With joint tenancy, they're seen as owning the entire interest together as a single group. There are no distinct individual shares. And the crucial feature here is the right of survivorship, or just akushendi.
Meaning?
Meaning if one joint tenant passes away, their interest automatically vanishes, and the surviving joint tenants automatically own the whole thing. It doesn't pass through the deceased's will.
Ah, okay. Different from tenants in common.
Very different. With tenancy in common, the co-owners do have distinct, although physically undivided, shares in the property. Maybe 50-50, 70-30, whatever they agreed. And there's no right of survivorship.
So their share can be inherited.
Exactly. If a tenant in common dies, their share passes according to their will, or under intestacy rules, if they don't have a will, to their own heirs, not automatically to the other co-owners.
Okay, that's a pretty major difference. And what about rights to use someone else's land, like you mentioned, maybe for a driveway?
Right. Those are generally called servitudes over land. An easement is the classic example.
Like a right-of-way.
Precisely. It's a right that benefits one piece of land, we call that the dominant land, allowing its owner to do something limited on a neighboring piece of land, the servient land, using a path, running pipes, things like that. It's a non-possessory right. You don't own that strip of land. You just have the right to use it for a specific purpose.
How do these easements get created?
They can be created in several ways. by an explicit agreement, a grant in a deed. They can also be implied by law, for instance, an easement of necessity. If a piece of land is completely landlocked after being sold off, it needs access. Or even by prescription, which means using a path openly and continuously for a very long time, as if you had the right.
Interesting.
And related to easements, there's something called a profit apprendre.
A profit?
Yeah, it sounds like profit, but it's a right to go onto someone else's land and actually take something natural from it, like timber, fish from a lake, minerals, gravel.
Ah, okay. So taking something from the land, not just using it.
Exactly. And then much simpler, there's just a license.
Like permission.
Just permission. It makes lawful what would otherwise be a trespass. Letting a friend park in your driveway for an afternoon or allowing neighbors to have a picnic on your lawn, it doesn't create any actual interest in the land itself, and it's usually revocable.
Got it. That clarifies those different types of rights.
Now, keeping track of all these rights, ownership, easements, mortgages, that's where land registration comes in. It's essentially the official public record.
The paper trail.
Sort of the modern, ideally digital paper trail, yes. It provides clear evidence of title, who owns what rights, and it makes land dealings much, much smoother. It answers the key questions. Who owns the land and how they own it, freehold, leasehold, etc.
Okay.
And complementary to this, you often hear the term cadastre. That's more like the public inventory of data about the land parcels themselves, their boundaries, size, location, use, maybe even value. That answers where and how much land there is.
So why is this registration system so incredibly important for you, the individual landholder, or even for a country's economic development?
Oh, the advantages are huge. Really significant. Firstly, and maybe most importantly, it provides far greater security of tenure.
Peace of mind.
Exactly. When you know your land rights are clearly recorded and legally protected, you're much more likely to invest in that land, build a better house, improve your farm, you know.
Makes sense.
Secondly, it dramatically increases access to credit. Banks are far more willing to lend money when land rights are clear and can be easily pledged as security, as collateral for a loan.
Right, because they know what they're getting security over.
Precisely. And thirdly, it just makes land transactions, buying, selling, leasing, much faster, more reliable, and generally less expensive. Because ownership is transparent and easy to verify, you reduce the need for those complex, time-consuming historical title searches.
Okay. So how did people do this before modern registration?
Well, historically, there were different systems. You had private conveyancing, which was basically lawyers passing bundles of old deeds and documents between each other. Very slow, inefficient, and unfortunately quite prone to error or even fraud.
Sounds messy.
It could be. Then you had registration of deeds. This was an improvement. It meant transactions were recorded publicly, which helped establish priority generally. Whoever recorded their deed first had the stronger claim. But, and this is a really key distinction, registration of deeds doesn't guarantee the title itself, it just records the transaction.
Okay. So it doesn't fix underlying problems with the title.
Not necessarily. Which brings us to what's often considered the gold standard.
The Torrens title system. What's fascinating here is how different it seems. What's its big advantage?
The Torrens system, or registration of title, is fundamentally more robust. It was pioneered in South Australia way back in 1858 by Sir Robert Torrens.
Okay.
Its absolute game-changing feature is that the state, the government, actually guarantees the title shown in the register. The register itself is taken as conclusive proof of ownership.
The state guarantees it.
Yes. This principle is called indefeasibility of title. It means your registered title is, generally speaking, unchallengeable. It cannot be defeated, except in very specific circumstances, like proven fraud involving the registered owner.
Wow.
So it means you usually don't need to delve into complex history or old documents. You look at the current certificate of title, and that's your proof. It simplifies buying, selling, and mortgaging land immensely.
That sounds much more secure. Okay, let's unpack a potentially contentious area now.
Yeah.
Governments often have the power, right, to take private land, even if the owner doesn't want to sell, for public purposes.
Indeed. This is known as compulsory acquisition or eminent domain in some places.
That could be controversial.
Very. It's a power that's deeply ingrained in legal systems worldwide. Governments argue it's necessary for public projects like roads, schools, hospitals. But its application, especially around two key issues, is constantly debated.
Which are?
Firstly, what truly qualifies as a public purpose, and secondly, is the compensation offered truly fair and adequate?
Right. Has the definition of public purpose changed over time?
Oh, definitely.
Yeah.
Historically, particularly during colonial times, say in Tanzania, the interpretation could be extremely broad. Sometimes, disturbingly, it was even used to justify things like racial segregation schemes, leading to the forced removal of indigenous communities from valuable land.
That's awful.
Yeah.
So how has the law evolved to try and prevent that, to protect citizens and ensure fairness?
Well, modern constitutions, like Tanzania's 1977 constitution, now explicitly guarantee the right to property, and they stipulate that any deprivation, any taking of land must be done according to law and, crucially, must include fair and adequate compensation.
Okay.
And specific laws, like Tanzania's Land Act of 1999, go further. They advocate for full, fair, and prompt compensation based on market value. And that's supposed to include not just the land value, but also things like disturbance allowance, transport costs if you have to move, maybe even lost profits for a business.
But the definition of public purpose itself, is that still debated?
It often remains an open question, yes. It can be subject to interpretation by governments and courts, and it's frequently at the heart of disputes. And unfortunately, despite these legal frameworks, evidence suggests that land acquisitions, sometimes through legal loopholes or even illegal means, can still disproportionately impact vulnerable communities, like pastoralists, leading to ongoing land insecurity and evictions in some areas.
It's a complex balance between public need and private rights.
A very difficult balance.
Okay. So shifting back to the individual level, what does this all mean for you, the listener, when you're maybe buying your own home or investing in property? Are there crucial legal quirks in the sale contract you should be aware of?
Absolutely. The contract of sale itself is fundamental, and there are some common law principles that can surprise people. One really important one is the sole risk principle.
Sole risk.
Yeah. Imagine you sign a contract to buy a house, you've agreed on the price, signed the papers, but maybe the closing date when you actually take possession is a month away. What happens if, during that month, before you move in, a fire breaks out and damages the house? Under common law, the risk of that damage actually passes to you, the buyer, the moment the contract is concluded, becomes binding, even if the seller is still living there.
Really? Even before you own it legally?
Even before legal title formally transfers. Which is why smart buyers always make sure the property is insured in their name right from the date the contract is binding, not just from the day they get the keys. You can often modify this by agreement in the contract, but the default rule can be a shock.
That's a huge tip. Okay, what about a voetstoots clause? That sounds like some kind of legal speed bump.
Chuckles. Yeah. Voetstoots. It's an Afrikaans term used in some common law systems, essentially meaning the property is sold as is, or with all its faults.
Okay, so the seller isn't responsible for defects.
It generally protects the seller from liability for both patent defects, ones that are obvious and visible, and latent defects, hidden ones you couldn't easily discover.
So buyer beware.
To a large extent, yes. However, and this is the crucial limit, this protection doesn't apply. If the seller knew about a serious hidden defect and intentionally concealed it with the intent to defraud you, the buyer.
So deliberate deception voids it.
Exactly. If they actively covered up, say, major termite damage or a cracked foundation they knew about, you could still have a claim against them. The burden of proof is on you, the buyer, though. And there's also a strong duty on the seller to disclose serious latent defects that make the property actively dangerous or hazardous.
Okay, that makes sense.
And this whole contract phase also links to a concept called equitable conversion.
Equitable conversion.
Yeah, it's the idea that once a valid contract of sale is signed, equity sort of sees the buyer as having become the equitable owner of the property even before the legal title is formally transferred by deed.
So you have a kind of ownership right already.
An equitable one, yes. The seller still holds the legal title, but they're often seen as holding it sort of in trust for you. Their main remaining interest is the right to receive the purchase payment. And as we mentioned, the risk of loss often transfers to you, the equitable owner, at that point, too.
It really highlights how important that contract signing is.
It's a pivotal moment, legally.
Okay. And what about financing such a significant purchase?
Yeah.
Most people need a loan. That's where mortgages come in.
Exactly. A mortgage is essentially using property, usually land and buildings, as security for a loan.
Why is land so often preferred as security?
Well, several reasons. It's generally stable in value, often appreciates over time. It's immovable. You can't hide it or easily destroy it, and its ownership can be clearly recorded, especially with good registration systems, makes lenders feel more secure. And a really core principle in mortgage law, designed to protect borrowers, is once a mortgage, always a mortgage. It means the law strongly protects your right as the borrower, the mortgager, to get your property back free and clear once the debt is fully repaid. This is called the equity of redemption. The lender can't put clauses in the mortgage agreement that unfairly block or clog this right to redeem. You remain the owner throughout the mortgage period. The bank just holds a security interest over the property.
So the bank doesn't actually own your house while you have a mortgage?
No, not in the modern sense. They have a charge or security interest. And mortgages can take different forms. Formal legal mortgages created by deed, equitable mortgages created perhaps just by depositing your title deeds with the lender. Sometimes even informal agreements can be recognized.
Okay. And if things go wrong, if the borrower defaults?
Then the lender, the mortgagee, has certain remedies. They can sue you personally for the debt. They might have the right to take possession of the property, or most commonly, they have the power to sell the property to recover the outstanding loan amount.
What about foreclosure, where the bank just takes the property completely?
Interestingly, in some jurisdictions, like Tanzania, as mentioned in our notes, the remedy of foreclosure, where the lender applies to court to basically extinguish the borrower's right to redeem and become the absolute owner, has actually been abolished. The primary remedy is sale, which is generally seen as fairer to the borrower, as any surplus proceeds after paying the debt go back to them.
That seems like an important protection for homeowners. Okay, let's move to another stage in the property life cycle. What happens to land and property when someone passes away? This must be a really sensitive and important part of land law.
It is indeed a very crucial area. This falls under the law of probate and administration of estates.
Probate.
Yeah. If a person dies leaving a valid will, the legal process to validate that will and handle their property according to its instructions is called probate. The court grants probate to the executor named in the will.
And if there's no will?
If someone dies intestate without a valid will, then the court grants letters of administration to appoint an administrator or administratrix to manage and distribute the estate according to specific intestacy laws.
Okay. And what do these executors or administrators actually have to do?
They have significant legal duties and responsibilities. They need to collect all the deceased person's assets, identify and pay off any outstanding debts and taxes, figure out who the legal heirs or beneficiaries are, according to the will or the law, and then distribute the remaining estate correctly.
That sounds like a big job.
It can be. And there are rules about who can do it. Minors or people deemed of unsound mind can't be granted these roles, for example. And if someone involved, like a potential beneficiary, has concerns, they can enter a caveat to temporarily block the grant. Also, if an administrator doesn't do their job properly, say they fail to provide a proper inventory of assets to the court within the required time, often 6 months, their grant can be revoked. Courts take these duties seriously.
And this area, inheritance, must also bring up some complex and maybe sensitive social issues.
Definitely. For example, the issue of inheritance for illegitimate children can be quite complex and varies between legal systems. Under certain laws, like those currently in Tanzania that were mentioned, if a father dies intestate without a will, his illegitimate children might be excluded from inheriting from his estate automatically under the law.
Really?
Yes, although they typically can inherit from their mother's estate if she dies intestate. However, they can inherit from their father's estate if he specifically included them in a valid will, or if they are otherwise legally legitimized according to law. This really highlights how law intersects with complex family structures and social norms, and how different systems handle it.
That leads to another point. How do courts decide which law applies to inheritance? Especially when you might have someone whose family followed customary traditions, but maybe they lived a more modern life. Customary law versus statutory law.
That's a classic choice of law problem, and it can be tricky. Courts have developed various tests over time to figure this out.
Like what?
For instance, they might look closely at the deceased person's actual way of life. Did they essentially abandon the customary way of life for, say, a more Christian and non-traditional way, as one case put it? If so, the court might lean towards applying modern statutory inheritance law.
And if they live traditionally?
Conversely, if someone lived primarily in a rural area within a community strongly adhering to custom, there might be a presumption that customary law should apply to their inheritance unless proven otherwise. It often comes down to the specific facts and evidence about how the person lived their life. It shows the ongoing complexity and the need for courts to weigh cultural context carefully.
Fascinating how the law adapts or tries to. Okay, one more big area, especially relevant in cities today. Land law traditionally thinks, horizontally. You own the ground, maybe up to the sky like we discussed. But what about apartments, condominiums, offices stacked in multi-story buildings? How do you legally own just a piece of a building, a slice of the sky?
Right. This is precisely the challenge that the concept of unit titles, known elsewhere as condominiums or strata titles, was designed to solve. It's a legal mechanism to allow individual ownership of defined spaces within a larger building.
So instead of owning a piece of the earth,
You own a defined three-dimensional space, your apartment unit, for example. And crucially, you also get shared ownership, usually as tenants in common with all the other unit owners, of the building's common property.
like the lifts, hallways.
Exactly. Lifts, lobbies, hallways, the roof, the gardens, driveways, all the bits everyone uses.
How did this fit with those old legal ideas, like owning up to the sky?
Well, historically, it clashed quite significantly. Those old maxims, cuius est solum majus usque columnum, and quicquid plantatur solo sedit, they really imply continuous vertical ownership from the ground up. The idea of owning just, say, the 10th floor was legally awkward under traditional frameworks.
So new laws were needed.
Precisely. Introducing unit title systems often required specific legislation, specific amendments to existing land laws to create the legal framework allowing this kind of horizontal or strata division of ownership within a building. It had to explicitly override or modify those older concepts for multi-unit buildings.
So thinking about the listener again, what are the big advantages for someone like you looking for property, maybe in a rapidly growing city where standalone houses are expensive?
Unit titles offer some really significant benefits. First, affordability. They're often more economical than comparable detached housing, making private ownership accessible in high-value urban areas where land itself is scarce and pricey.
Okay.
Second, shared maintenance. You benefit from shared upkeep and maintenance costs for those common areas, the roof, the structure, the grounds, which is often handled professionally by an owners association or body corporate.
That sounds convenient.
It can be, yet you still have individual ownership of your unit. You pay your own separate property taxes. You can get your own mortgage on your unit, just like a standalone house. Plus, there's often enhanced security in these developments, and you get what's called a unit factor or fractional share. This usually determines your voting rights in the owners association and your share of the contributions towards maintaining the common property.
Okay. And how do these individual units actually get created legally? It sounds like it must be a pretty precise process on paper.
It is quite structured. The developer has to go through several key steps. First, obviously, getting planning consent for the building and then the building permit to construct it.
Right.
After construction, they apply to the land registrar, the government authority, to formally register what's called a unit plan or strata plan. This plan legally divides the building and land into the individual units and the common property.
And then each apartment gets its own title.
Exactly. Each unit then receives its own separate certificate of a unit title or equivalent document. This is its own distinct title deed, just like a certificate of title for a piece of land. Finally, the unit owners automatically become members of the owners association, or body corporate, which is responsible for managing the common property, and they often employ a professional managing agent to handle the day-to-day operations.
Wow. Okay, we've covered a huge amount of ground today, haven't we? We've journeyed literally from the definition of dirt and land all the way up to the complexities of owning and sharing a building in the sky.
We certainly have.
And it's really clear, I think, that land law is far from some static, dusty old thing. It's very much a living system, isn't it? Constantly adapting to history, to society's needs, even to technology.
Absolutely. And if you connect all these pieces to the bigger picture, it just highlights how incredibly fundamental property rights are to our lives. I mean, everything from how we build our homes,
How we secure loans.
how families pass on legacies, understanding these, let's call them nuggets of land law. It really empowers you, the listener, to navigate the world around you with much greater insight and hopefully confidence.
Yeah. So what does this all mean for you listening? We've seen how these traditional concepts, some centuries old, meet modern realities like urbanization and apartment living. We've seen how the law constantly tries, sometimes successfully, sometimes maybe less so, to balance individual rights with community needs, public purpose with private property. And all this, I think, raises a really important question for us to maybe leave you with. How do you think these evolving ideas about land ownership, especially in our rapidly urbanizing world, might continue to reshape our communities, our cities, and even our personal freedoms in the decades to come?
That's a great question to ponder.
Definitely something to mull over.